this is a clear indication of where the Supreme Court of Virginia is going to go with regard to implied versus express powers. And it's obvious that they're looking for the declarations to be much more extensive and much more finely written than they may have been in the past. I think for too long, perhaps, we've been under the belief that there were some implied authority and some implied powers that come out of some of the plain meaning of the language of the restrictions, especially the one about no modifications, alterations, or other improvements. Language, I think we've been relying on that as being rather open-ended and extensive, and the Supreme Court basically shut its doors on that kind of a takeaway. I think a couple of takeaways from the case are, one, we need to be much more careful when we start any process that involves violations, that our notice of violation letters must be much more comprehensive and exacting to the details. Association beware would be my catch-all.
Right.
And my second is that you better look very carefully at any guidelines or standards that you've adopted, and quite frankly, make sure that if the document gives you the ability to adopt guidelines, that you adopt guidelines and not standards.